So, elders, leaders, community members, it is, of course, wonderful to be back here in Vancouver, to be among friends, family, and colleagues, and to talk about the important work that you are carrying forward, developing a province-wide First Nations justice strategy in partnership with the provincial government, work that is so urgent, vital, and long overdue. It is work that so many of us in this room fought so hard to advance over many years. And it is an important sign of progress that collectively you are putting together a joint provincial strategy that is finally being drafted and implemented, and it will take us all. So since I spoke to the leadership of British Columbia this past November, there have been a few developments. Things have changed a bit. Perhaps you are aware of them. Perhaps not fully unexpected, but certainly an eventful time. And to the so many of you who reached out to me, who reached out to Tim with your words of support and encouragement, we thank you very much. So, of course, when I spoke to you last in November, I was still the Minister of Justice and the Attorney General of Canada. And the focus of my remarks then was about how true reconciliation requires courage, audacity, innovation, and a different approach to politics. Implied in this was how the challenges we were seeing in transforming laws and policies through new recognition of rights and implementation framework illustrated that we need to govern and make decisions in new ways. Indeed, when I went to Ottawa in 2015, I carried with me the belief that how we govern ourselves as Indigenous peoples carries important lessons for which Crown governments would do well to learn from. That belief is stronger today than ever before. Today I want to offer a few reflections on the past few months and the past few years, and in particular what lessons it might hold for the important work that you're engaged in of transforming the relationship between Indigenous peoples and the justice system. One of the developments over the past few months was that, finally, in my last act as Minister of Justice and Attorney General, I issued a directive about the conduct of the Crown in civil litigation with respect to Indigenous peoples. The directive lays out 20 guidelines aimed at shifting how litigation is conducted in a more respectful, recognition-based, and focused on early settlement and measures to simplify legal proceedings. It is only a step, but it is a really important step and a step in the right direction. In fact, this directive took a long time to be finalized and released. From the time I first announced we were preparing it back in July of 2017, there were challenges. There were obstacles and there was some resistance. In order to move the directive along, a lot of work was done, including testing our approaches, educating and training lawyers, dialogue with experts, both internally and externally to the government, and starting to make shifts in litigation practices that would come to be expressed formally in the directive. I am pleased that the work of implementing the directive is ongoing and within the Department of Justice, and this work must continue. There were some within the establishment who were fearful that shifting from the norm of how the courts had been used against Indigenous peoples would be a costly mistake. Some who did not seem to understand that adversarial processes and the work of reconciliation are and will always be fundamentally in tension and typically at cross purposes. Some who importantly did not, and perhaps still do not, realize that uncertainty, conflict, and unpredictability arise because the denial of rights, not because of their recognition. And if not for the moral and legal imperative for justice, it just makes good economic sense. I mean, is it not just common sense that when people's rights are affirmed and as peoples and governments they are recognized, that the foundations for working together, collaboration, cooperation, and peaceful coexistence are stronger? And when people's rights are denied and not implemented, the foundations for conflict and uncertainty exist. Because the reality that a directive on litigation from a minister was even needed speaks volumes to the much more foundational challenges we still face. The patterns of perpetual, expensive, and seemingly endless litigation that we've fallen into is a symptom of a much deeper dilemma rooted in the history of our country and about how the law and the justice system has operated. Indeed, all of these terms, justice system, rule of law, administration of justice, and others, have meant something starkly different for Indigenous peoples than other Canadians. And it is that difference, that fundamental fact, that Canada's justice system has historically had a role in perpetuating injustice for Indigenous peoples, that we are all working so urgently to confront and change. In my recent testimony before the Justice Committee on February the 27th of 2019, respecting the SNC-Lavalin controversy, I observed that, quote, "The history of Crown Indigenous relations in this country includes a history of the rule of law not being respected. And I have seen the negative impacts for freedom, equality, and a just society this can have firsthand. I also stated that we either have a system that is based on the rule of law, the independence of the prosecutorial functions, and respect for those charged to use their discretion and powers in a particular way, or we do not. As these statements highlight, the rule of law is a principle intertwined with the highest values we uphold as society: fairness, equality, non-discrimination, upholding basic rights and fundamental freedoms, limitations on power, privilege, and undue influence. Values, when respected, applied, and upheld, are the critical foundation for inclusion, social cohesion, and democracy. When violated, there are significant risks of conflict, corruption, and the decay of the bonds and the ties that allow diverse peoples to live and build society together. And of course, as Indigenous peoples, we have our own vital and important understandings and application of the rule of law within our own traditions and legal orders, within our diverse protocols and teachings and how our laws are expressed, whether orally, in story, in art, or in writing. One sees how all of us have a responsibility to uphold the law and the wide range of mechanisms, customs, practices, and expressions that must be utilized to ensure that occurs. And within our oral traditions, there is a paramountcy that we must place on the truth. It is recognized that if we do not voice what is true and pass it on, our societies will fracture and erode. Speaking and truth-telling can never be separated. This is a lesson which I believe Crown governments and our national system of politics certainly can learn from. With respect to Indigenous peoples, the failure to uphold the rule of law in the history of Canada has been one significant factor in the history of Crown Indigenous relations. We all know this too well. Historic treaties have been violated, the legal requirement for treaty making ignored, the direction for the recognition of the Indigenous relationship with the land in the Royal Proclamation of 1763 ignored, the imposition of an explicitly race-based, segregated, and unequal Indian Act system, and how, right up until today, Indigenous peoples have been forced to prove their existence, the existence of their rights enshrined in the Constitution of 1982, in ways that charter rights, also enshrined in the Constitution in 1982, have not been. Of course, when I became Mojag, I had no illusion about this reality. I was not naive to the challenges, but rather embraced them, and still do, despite all that may have transpired over the past few months. This is the reality I had fought to change alongside all of you, and the reality I was committed to challenge in Ottawa. I believed then, and I continue to believe now, that making the fundamental shift from relations based on denial to those based on the recognition of rights is urgent, imperative, and requires transformative, foundational changes to laws, policies, and operational practices of both the federal and provincial governments. It also requires Indigenous nations to dramatically advance in tangible and innovative ways the work we must do to rebuild nations and governments, to set priorities, organize as proper title and rights holders, reimagine and strengthen governance and their legal institutions, and very importantly, increase the capacity to develop, legislate, and enforce their laws. This work should also be nonpartisan. This is not an arena of work conducive to political expediency, partisan games, cynical half measures, or rhetoric not backed up with action. This requires boldness, courage, and a vigorous agenda for change from all of us. And where progress is being made, the momentum must be maintained and encouraged. This need is clear across the spectrum of political, economic, cultural, and social issues that we face as Indigenous peoples and as a country. Nowhere is it clearer than in what you are discussing today, the relationship of Indigenous peoples in the criminal justice system. And that is why I so greatly applaud the work that the leadership in British Columbia with the province is doing to undertake this joint work. Against this backdrop of the essential shift from denial to recognition and how it relates to the true meaning of the rule of law, let me offer a few more specific examples or observations about Canada's criminal justice system and the changes that are needed. I'm not going to go into detail about the legacy of colonialism, which is pervasive and ever present in the criminal justice system. We all know the statistics are stark. And I know that you are discussing them over the next number of days. So like all of you, I know people that have from a young age gotten stuck in endless cycles into and out of the criminal justice system. This often starts, as I've said many times before, with a nonviolent crime and escalates to a life within the system, including the vicious cycle of court appearances, court orders, breaches of court orders, and then returns to custody. Throughout all of this, marginalization and victimization increase. The legacy of colonialism plays itself out in an ever more intense way in the daily life and experience of that person, victims, and those around them. Breaking this pattern requires multi-level approaches, and I'm glad to see that your strategy and the work that you are doing is framed as such. That the ultimate goal of the strategy you are designing is to figure out the proper relations between self-governing and self-determined nations regarding the administration of justice and the province's system, roles, and responsibilities also for the administration of justice. This is big picture. This is transformative. And also that your strategy, in addition to the systematically supporting and advancing that vision, will pursue immediate and tangible changes to address the urgent challenges that arise regarding how Indigenous peoples come into contact with the justice system and what transpires when they do. So let me reflect a little bit on the immediate changes and challenges and the bigger shifts in relation to self-governments. The types of immediate shifts that we focus on are well understood. We talk about restorative justice. I am a huge champion of restorative justice and know that governments need to invest significant dollars in the promotion of more restorative justice measures. We talk about the implementation of the Gladue decision of the Supreme Court of Canada in sentencing. We talk about the formation and recognize and acknowledge the work of our organizations, work like the Native Court Workers Association. We talk about retraining those within the justice system, such as prosecutors and the judiciary, and the development of First Nations sentencing courts, changes to the jury system and bail processes, and so on. And I have to give a plug because Bill C-75 is in the Senate, and this is the criminal justice reform, and I hope that is passed in this Parliament. All of these measures are vital and must be addressed in any strategy that is developed. Additionally, is the required work of supporting and investing in proactive programs and capacity that help build healthier communities and provide new supports, as well as significant innovation in rehabilitative measures in the corrections system. To be clear, making these immediate and incremental shifts also requires some far-reaching changes to Crown legislation and policy, both federal and provincial, in the near term. For example, and it is no secret, I have long believed and continue to believe that mandatory minimum penalties perpetuate the crisis of the relationship between Indigenous peoples and the criminal justice system, and that many of the immediate challenges cannot be effectively addressed without the majority of mandatory minimum penalties being removed. To say it simply, MMPs feed the cycles of incarceration and over-incarceration, and our work needs to break those cycles. I firmly believe it is essential to moving forward and will continue to aggressively advocate for their removal. Another example is of a different nature. As First Nations people, we intimately know, of course, the tragedies that have afflicted individuals, families, and communities. For many Canadians, however, there has been more of an awakening to these realities in recent years, with tragic stories of Colton Boushie and Tina Fontaine, for example. Painful, and again, tragic realities and experiences have been starkly revealed. Long-standing concerns with the administration of justice have had a light shone on them, as Canadians from coast to coast to coast have begun to understand in new and renewed ways the histories and legacies that have led to these enduring challenges and the direction of change we must pursue. Of course, responding to and improving the existing justice system is only one aspect of the work, part of addressing the symptoms of what is wrong. But we also must address the underlying foundations. The core work is the work you must do as Indigenous nations, the work of self-determination and rebuilding your governments and legal orders with the support and partnership of the provincial and federal governments. There remains significant unfinished business or unfinished work to accomplish before Indigenous peoples have access to appropriate systems of justice, including Indigenous courts, so that they can enforce tribal and other laws as part of a multi-level system of evolving cooperative federalism, and that respects Indigenous legal orders. In the fall of 2018, I had announced plans for dialogue with Indigenous peoples on how to advance this. Venues for such dialogue, I hope and ensure, must continue. Some areas for justice reform as an aspect of self-government and self-government implementation will be easier than others. The work is already underway, albeit not fast enough, nor as well coordinated as it could be. But we should have no illusions, though. Doing this work, as it relates to the criminal justice system, will be one of the hardest, if not the hardest, arena for change. At Confederation, our criminal laws were confirmed as falling under federal jurisdiction in Section 91 of the Constitution. From that time onward, the criminal law of Canada was built up based on British law and with the passage of the first criminal code in 1893. Of course, in parallel was the launching of another reality, the passage of the Indian Act, which regulated the lives of First Nations peoples and made every aspect of our way of life many aspects of our way of life criminal. In the colonial mindset, rather than subjects to be protected by the criminal laws of Canada, we were and are often objects to be protected from. Rebuilding our own systems of justice, including our own courts and institutions, is vital to addressing this reality, and it is incumbent upon First Nations to lead it. In order to be effective in the administration of justice, it is also important we recognize, as mentioned above, the foundations that must be laid first. Moving out from under the Indian Act into systems and institutions built around our own constitutions is vital, and is building up the internal capacity for operating and growing those institutions. We also need to turn our efforts to the hard questions, including the ways in which we will choose to enforce our laws and how that enforcement will ensure the protection of all within our nations, including particularly the most vulnerable. We also have to think in very systematic and coherent ways about the issues of transition from the existing justice system, one which includes recognized roles for Indigenous laws and systems. There will be no one-size-fits-all model. It will necessarily have to look different and be attuned to how nations are driving forward their work and rebuilding their governments and their priorities that must be addressed. There will be issues of economies of scale and financing, regulation and accreditation, and what has in the past been called problems of pan-Indianism, where we conflate different cultures under the general rubric of being Indigenous. Of course, this work moving forward also requires the basic Crown recognition of Indigenous title, rights, and governments to take place. This is something that little over a year ago I expected was going to happen imminently, following the Prime Minister's historic words in the House of Commons. As you all know, this has not occurred, and I fear we may have temporarily fallen back into a less audacious, less meaningful conversation and mode of work that, while perhaps more comfortable, will not achieve the transformative space that is required. Of course, quarter-century-old policies need to be rewritten and negotiation approaches updated. But ultimately, the lifeblood of colonialism is written in the laws of this country, including the Indian Act, and how these laws deny our title and rights, and until the laws of Canada are changed to be based on recognition, fundamental patterns that need to be altered will remain with us. While steps forward are being taken, they are not happening as coherently, systematically, and quickly as is needed to set us on a proper and necessary path based on rights recognition. My fear and disappointment is that despite sounding the alarm, providing advice, pushing and challenging, sharing perspectives of lived Indigenous experience, providing a lens into the reality of being Indigenous, the federal government has fallen back once again into a pattern of trying to, quote, manage the problem with Indigenous peoples and make incremental and limited shifts rather than transforming the status quo. In my view, it is never appropriate or proper to have as a goal managing the challenges and the byproducts of colonialism. The goal must be to right the wrongs, to address the wrongs, to change patterns, transform the foundations, and all that we do must be framed to achieve these goals. Again, this is where Crown governments have much to learn from us. We have experienced colonialism. We understand it, and we have the solutions. Despite the setbacks, I am confident that we will not move away from our solutions, and we will remain vigilant. We have come so far. Indeed, Although it was my expectation that the review of laws and policies that the federal government was to undertake in accordance with the 10 principles that the government released in July of 2017 would have happened earlier in the mandate, now at the 11th hour, there is a push to revisit the so-called comprehensive land claims policies and self-government policies. Kim Baird and Tom Isaac, as I understand it, have been tasked with this work. When it comes to the administration of justice and as it relates to the work that the BC leadership is undertaking, I believe that it is through the revised policies on self-government, including the new fiscal policy with respect to funding self-governments, that the internal direction to the federal government will be given on the scope and extent of what the government sees possible in this area. And it goes without saying that we need to ensure, with respect to justice and other matters of importance between Indigenous peoples and the Crown, that our voices must be heard and these policies and laws revised based on recognition, not denial. So this brings me to some final observations that I would like to share about the work of advancing reconciliation, including transforming the justice system, and what this tells us about politics and political culture that currently exists in Canada. To say it differently, reconciliation reminds us how desperately a different form of politics is needed in this country, one with a new political culture. Reconciliation is a challenge that is vital to the survival and well-being of children, women, and communities across this country. To meet this challenge, hard choices, innovative actions, transformation in laws and policies, new understandings and attitudes, and new patterns of behavior are needed. Long-term vision is needed. A willingness to think concretely about the next generation is needed, and how to build that. The leadership to not take for granted the status quo of how things are, and to challenge them. The strength to know that this requires working across party lines, building support for bold ideas that can endure. Over the last number of years, and especially over the last number of months, I have heard from Canadians all across the country yearning for this new kind of politics. And in this regard, I think we, as Indigenous peoples and leaders, have much to share and teach the rest of the country about how, despite differences, our diverse teachings encourage us to strive to maintain a focus on achieving consensus. How, despite great obstacles, our legal orders and systems of justice have been maintained, and we continue to work to improve and advance them. And how we understand the roles and responsibilities that must be played within our governments and societies, how all of these roles are intended to contribute to advancing the well-being and health of all. Doing the work of Indigenous, or as Indigenous self-governments, to develop our own systems for the administration of justice, while also reforming the current systems of justice that fall under other jurisdictions, will be a major and essential contribution to the future of Canada. The overall success or failure of rebuilding Indigenous nations in Canada and the successful implementation of self-government will in large part be determined by how well Indigenous nations can enforce and adjudicate their own laws, as well as other governments' laws, and how well such systems fit within the broader legal system in Canada. I look forward to seeing how your strategy continues to develop and how it is implemented over the coming years and how it will affect this much-needed transformation. And I also look forward to finding ways that I can support this vital work. So as a last word, I just want to say, or I just want to share, that today and every day, I do remain optimistic and hopeful. Despite the challenges of the past few years and months, the path to progress and change is marching forward, and I think constructive work led by Indigenous peoples is accelerating. We are seeing work being done together in ways that we have not seen before, and this is vitally important. This does not stop, nor is it dependent on one voice or one person. Of course, this is collective work that generations before us have carried forward and which we are carrying forward now. The vigilance we must continue to have is to ensure that the work that is being done remains grounded, rooted in principles and standards, and that the solutions being developed will truly result in honoring and respecting Indigenous laws, governments, and jurisdictions, whose ultimate goal is to improve the quality of life for our peoples, so we can care for our peoples, communities, and the lands as we must. Indeed, as self-determination and self-government advances, we see how it also strengthens the well-being of Canada and all Canadians, including our social fabric, cohesion, culture, and economy. Gela kasla for the work that you do. I look forward to seeing it continue. Thank you.